In this video lecture, we're going to look at the American federal system, its origins, and some of the issues surrounding the American federal system. Now first, I guess we need to define what a federal system is. It's a political system in which there is a constitutional sharing between the national government and the regional governments. We call our states, Canada calls theirs provinces. In the period of the Articles of Confederation, the United States was governed by a confederation. This is one in which the national government derives its power from the states. This led to a very weak national government. Now the framers attempted to remedy the problems by creating a new system. However, they could not go to a unitary system, which we'll explain in a minute. And so they tried an experiment. Now, if you run into people who tell you that the drafters of the Constitution knew exactly what they were attempting to do with the creation of a federal system, it's true that they probably haven't read the record. It was an experiment. And quite honestly, they weren't real sure whether it was going to work or not. And what we're going to determine a little bit later is that the system of federalism, the method of federalism, has changed rather markedly over the course of 200 years. We were the first country to adopt a federal system in which both the national government and the state governments derive their authority from the people. Very different from a unitary system where the national and regional governments derive all of their authority from a strong national government. The powers are exclusive, prohibited, and shared, and the terms mean exactly what it sounds like. In an exclusive system and an exclusive set of situations, only one level of government can perform that function. Prohibited, one or both levels cannot perform a particular function, and in shared, both levels of government can perform. Some examples. Foreign affairs and defense, citizenship determination, and regulation of interstate commerce are exclusively national powers. States and states alone can ratify amendments to the Constitution, and it's implied to establish that of local governments. Both the national government and the state governments are prohibited from certain kinds of powers. The national government is prohibited from ex post facto laws, that is, laws which make something illegal after it's been done. Taxes on exports, a part of the compromises of the Constitutional Convention, are suspending the writ of habeas corpus, and later we'll explain what a writ of habeas corpus happens to be, except in very dire circumstances. States, under Article 1, Section 10, are limited in the kind of powers that they can perform. Foreign affairs and defense, again, are a no-no for states, but not for the national government. States may not make binding agreements between themselves without the power of Congress, without Congress's consent, and they may not impair an obligation of contract. Now that's led to some very interesting cases in the Supreme Court. Examples of shared power: taxing and spending, borrowing money, making and enforcing law, chartering banks and corporations, eminent domain, that is, taking of private property for public use, so long as there's just compensation, is a shared power of the national government and of the states, and to establish and operate court systems. Some other important concept, very important concept, Article 6 of the Constitution says, "The Constitution and laws and treaties of the United States shall be the supreme law of the land." End of sentence. You have seen in recent years or recent weeks various politicians talking about how you don't have to pay attention to what the Supreme Court has ruled in the case dealing with same-sex marriage. Sorry, Tonto. This Constitution and the laws and treaties of the United States are the supreme law of the land. Some other very important concepts are the Reserve Clause, that the powers not delegated to the United States by the Constitution nor prohibited by it to the states are reserved to the states or to the people. Now there are some politicians, our own inimitable Rip Perry being one of them, who want to put a period after the word states. If the Constitution does not specifically spell it out, then it's prohibited. Well, that's not what the 10th Amendment says. Some other important concepts. which led to a significant expansion of federal power. McCulloch versus Maryland is one of the first cases, and we'll play with that. Congress shall have the power to make all laws necessary and proper for the carrying of into execution the powers that have been granted in the Constitution. Another important concept is concurrent powers, powers which are shared by either level of government. Taxing and police powers are examples. Obligations of the nation to the states, states to the nation, and states to each other are also considered in the Constitution. States are to be protected against invasion and domestic violence by the national government, and a guarantee of republican form of government. I don't know how much you may know about Shays' Rebellion, but Shays' Rebellion directly led to this protection against domestic violence. If you've never read or paid any attention to Shays' Rebellion, there's a pretty good section in Wikipedia that will help you understand what it's all about. Now, the states have some obligations to the national government. They have to obey and carry out federal law. Sorry, if you happen to be the county clerk in a county in Kentucky and you don't want to issue marriage license to persons who are the same gender, you are obligated by the Constitution to obey and carry out federal law. States must also participate in the amending of the Constitution and to participate in national elections. States have some obligations to each other as well. They must render full faith and credit to the legal acts and processes of every other state. And so if a person is legally married, this came up before the Supreme Court decision on same-sex marriage. If a person is legally married, if the state of New York decided to allow people to be married of the same gender to be married, when they move to Texas, they are married in Texas because of the full faith and credit clause. Extradition: if a person commits a crime in one state and then flees to another state to avoid prosecution, the state to which that person has fled is supposed to return that individual to the state for prosecution. Now, fascinatingly enough, the Supreme Court has not made this an absolute requirement. It is pretty much up to the state who is holding the person to decide whether they wish to have that person extradited. And that the privileges and immunities of citizens of the several states, particularly the right to travel, are guaranteed. Now, how do we work out the details? Well, they may be settled by the Supreme Court under its original jurisdiction. The full faith and credit clause can be brought into effect. The privileges and immunities clause can be brought into effect. The extradition clause can be brought into effect, or there can be interstate compacts. Over 200 of those exist today. I'll give you one example. If you have a valid driver's license in Texas, that driver's license is valid in every other state in the United States because of interstate compacts in which the states have agreed with each other to recognize each other's driver's licenses.